during investigatory interviews. My name is Bianca Cunningham. I'm a staff writer and organizer for Labor Notes, and I'm so happy to be with you all tonight. So here's how it's going to go. We are going to hear a presentation on Weingarten rights and representation from Robert. And then we're going to open it up on the last half hour for questions from the participants. It would be great if you could share any experiences you've had with Weingarten interviews, especially pointers that other attendees can benefit from when they represent workers at such meetings. You can do that in the Q&A section. And if you're joining us through Facebook, this is also live streaming on Facebook, we'll have a moderator there to share experiences or relevant questions and funnel them in so that we can ask them. Other than that, it's gonna be a little bit funky, but just ride with us. There was a presentation, a slide presentation that we were going to use tonight, but what we'll do instead is we'll do without it, and we will send it out in the email to follow this. So we'll send out the recording as well as the slideshow. And I'll just say a little bit about Labor Notes before I introduce Robert M. Schwartz. Labor Notes, for those of you who don't know, is a mixed media project. We do a monthly publication that covers the rank and file struggles or labor struggles in mostly North America, but all over the globe through the rank and file perspective. We like to say we were putting the movement back into the labor movement. And the other thing that we do is do trainings. And so we do troublemaker schools. Before COVID times, we would come to a city, invite a bunch of union members to come and do organizing trainings based on our best-selling book, Secrets of a Successful Organizer, or also do trainings amongst around many topics. So that's Labor Notes. And without further ado, let me introduce our special guests. So Robert M. Schwartz practiced labor law on behalf of unions for over 40 years in Boston, Massachusetts. Before entering law school, Mr. Schwartz was a member of several unions, including UAW and SEIU, the Teamsters as well. In one workplace, a South Boston warehouse, he helped organize a Teamsters local. He was also a leader in a successful campaign for rent control in Cambridge, Massachusetts. Since his retirement in 2016, he's continued to write for Labor Notes, including putting out new editions of his very popular series of labor law handbooks. These include The Legal Rights of Union Stewards, Just Cause, the FMLA Handbook, How to Win Past Practice Grievances, No Contract, No Peace, and the Labor Law Source Book. All of Mr. Schwartz's books are published by Labor Notes. Today's webinar is based on a chapter in The Legal Rights of Union Stewards, which is available for $20 plus shipping from the Labor Notes online bookstore. And so without further ado, welcome Mr. Schwartz. And you can go ahead and share your screen now.
Okay, thank you very much, Bianca. I'm glad to be here with what I suppose could be a few hundred people. Bianca said that about 700 had registered, so I hope you're all there. I'm looking forward to the presentation. The topic is a good one. The title is Assisting Workers During Investigatory Interviews. It could also be called Weingarten Rights, because it's based on a US Supreme Court case called NLRB v. Weingarten, V.J. Weingarten. The reason I say it's a pretty good topic to talk about is that it has not been destroyed by decisions of the Trump Labor Board. As all of you know, we have been the victims of a barbaric federal National Labor Relations Board for the last 3-odd years, which is totally under the control of right-wing Republican pro-business management labor lawyers. and they have destroyed several important areas of union labor law, including unilateral change law, and then most recently, new standards on profanity and what is called uncivil behavior in the workplace. For one reason or another, the Trump board has not issued any decisions on Weingarten rights or any significant decisions. Consequently, we're living with the case law that was in place during the Obama Labor Board, and we have several favorable rulings, and it's still a good area, and it's an area that all stewards, business agents, executive board members, et cetera, should study, because it's a way for us to help our members. It's a way for us to intervene. It's a way for us to help people keep their jobs. And it's a way for us to develop a good relationship, a relationship of respect by the members towards the union representative, who does a good job when he's needed or when she's needed at a disciplinary meeting. The Weingarten case is dated 1975. And just briefly, what it concerned was a company called J. Weingarten, which ran about 250 stores across the United States, many of which sold food. In one of the stores, a cashier was being surveilled by security. There was a suspicion that she was taking items without paying for it herself, checking it out to herself. She was called into a meeting with the store manager and with security, and they began to ask her several questions. She immediately asked for the presence of her union steward. The store was represented by, I think, the UFCW. Each time she asked, the request was denied. She tried to give an explanation of what happened. It seems like she was convincing them. At one point, they said, well, it looks like you didn't do anything wrong. We're going to send you back to work. At which point, so happy, she blurted out, that's great, because the only thing I've ever taken from the store was the free lunch, which we're all entitled to. Well, unfortunately, the free lunch program, which she had benefited from for several years because she had been employed there, had been stopped, maybe not to her knowledge. And the store manager immediately jumped on that and computed the fact that she had taken over 160 free lunches that year or the last 2 years, and demanded payment for those lunches. The union filed a charge at the NLRB contending that her request for representation should have been accepted, because the union knew that if there had been a steward present, this never would have happened. The company resisted, but the NLRB ruled in a very significant decision that employees were entitled to union representation on request when questioned about a matter that could get them in trouble or could lead to discipline. The company appealed the NLRB's decision to the Fifth Circuit. The Fifth Circuit reversed the NLRB. The NLRB then appealed to the US Supreme Court. And in 1975, the Supreme Court, in a 7-2 ruling, supported the NLRB's original decision, and in a lengthy decision laying out step by step, it created a set of rules called Weingarten rules, which create and define what rights we have, what rights workers have, what rights the union has during investigatory interviews. Before we get into the actual rules, let me say a word or two about jurisdiction. The NLRB, which created the rule, only has jurisdiction over the private sector because it enforces the National Labor Relations Act, which is a private sector labor law. That leaves the question, does this ruling apply in the public sector to state and local government workers? At first, there were some questions about that. However, over the years, almost all the states which have ruled on this issue have ruled that Weingarten rights apply to public workers in their state. For a while, it looked like New York State was taking a different position because the Supreme Court in New York did rule against Weingarten, but eventually the legislature corrected the problem by passing a special law giving Weingarten rights back to public workers in New York. As far as I know, the only big state that doesn't recognize Weingarten for its public employees is Texas. So let's begin on the coverage and the rules involved in Weingarten rights. First, bedrock rule. An employee is only entitled to union representation during an investigatory interview. So we need to know, what is an investigatory interview? Well, two components are needed for an investigatory interview. One, the employer has to be asking questions. That makes it an interview. And second, the questions have to be of a nature that leads the worker to believe that he or she could be in trouble depending on how they answer the questions. That they have a reasonable concern that they could get themselves, they could lose some rights, or they could suffer discipline depending on how they answer the questions. That's a investigatory interview. And in that situation, a worker has an absolute right to have the presence of his union representative. And if that representative is not supplied, if the company does not delay the interview or bring in the union representative, the worker has the right not to answer questions. There are some meetings with management which are not investigatory interviews, but workers sometimes think they are. For example, if a supervisor calls their worker to the office to go over some new procedures put out by the company in terms of safety, maybe lockout, tagout rules, to go over the procedures, or to go over a new attendance policy that's going to be applied in this department. Is that an investigatory interview? Does the worker have a right to demand the presence of their steward before that meeting goes any further? The answer is no. First of all, it's not clear that questions are being asked. In many of those meetings, the boss just talks and there's not any questions. But still, there could well be questions. So that might satisfy the first part of the test. But is that meeting one which reasonably should suggest to the worker that he is in trouble, that he could get in more trouble depending on how he answers the questions? The answer is no. Run-of-the-mill meetings with supervisors to explain procedures, to go over rules, to go over policies, do not necessarily qualify as investigatory interviews unless the supervisor is asking questions in an aggressive fashion that suggests that this worker is heading for trouble. Another meeting that is sometimes confused with an investigatory interview is a disciplinary announcement, a meeting to make a disciplinary announcement. So a worker is called in. The boss says, as you know, we've been going over your work. There's been complaints. And we've decided that we're going to suspend you for 5 days as a consequence of your infractions. Is this an investigatory interview? Can the employee demand the presence of his or her steward? Once again, the answer to that one is no, because one, the employer is not asking any questions. He or she is announcing a preconceived result. And there's no reason for the worker to believe that he's going to get in more trouble if he just sits through that meeting. So we're not entitled to union representation at disciplinary announcements. Now, we'd like to have the union there. The union really would like to be there to double check that the employer acted at least procedurally correctly in announcing or conveying the discipline. How can we ensure that the union is present during disciplinary announcements. The only way is to write it into the contract. And many unions have, in fact, written into their contracts a requirement that in any case where a worker is called in for the announcement of discipline, that a steward would be present at that meeting. And I encourage unions which don't have that language to get that language, to go and get that language. Another question that arises as a preliminary matter is whether an employer has a duty to educate or to explain to workers that they do have rights to union stewards or other representatives when questioned. In other words, does the employer have to say that to the worker when the worker is brought into the meeting with the supervisor or with the manager? And some people get confused about this because there is a similarity in several ways between Weingarten rights and another set of legal principles dealing with questioning by authorities. And of course, that other area is called Miranda rights. And that's based on a US Supreme Court decision entitled Miranda. And that decision requires the police to follow certain rules when they question individuals who are in custody about possible crimes. And under Miranda, when the Supreme Court issued its ruling, it included the obligation that the police inform the individual in custody that he or she has a right to a lawyer before answering any questions. And if the police don't make that announcement and then proceed to ask questions, any information that the police receive from that interrogation is disqualified. It can't be used against the employee. Well, it would have been great if the Supreme Court had included that one requirement in the Weingarten decision. I don't know why they didn't. Maybe in retrospect, they might have done so. In any case, there is no such obligation on the employer's part. And thus, the only way that workers are going to be educated about their Weingarten rights is if that education is provided by the union. And we certainly encourage unions to do a good job of educating all of their members about this topic and about their right to have a union representative present whenever they're brought in to a private meeting with management that they are afraid will lead to some harmful consequences or discipline.
Robert,
we might also want to explain to workers the advantages of having a union steward. There are some workers who don't really appreciate that. They think they're very good at explaining themselves, justifying themselves. They think they're better than the steward, and they don't really see the need for the union. We need to educate them and to explain to them that there are strong advantages to having a union steward present, both in terms of objecting to questions which are unfair, both in terms of adding information to the interview that would help the worker to avoid being charged with misconduct, and just being a buffer, in addition to being a witness in the event that the employer distorts what the worker said during the meeting. Some unions do educationals about Weingarten. Many have printed a Weingarten card. They give it to all the members. On that card, it is a request. The card itself is a request for union representation. And the worker is suggested that if you're called in to meet with security or meet with management, take the card out, hand it to the employer. And since the card makes a clear request for representation, legally it constitutes a request. If the employer ignores the card, proceeds to ask questions, it is violating Weingarten rights, and the interview is illegal. And we'll talk about a little bit later what remedies there might be for an illegal interview. The Weingarten decision makes clear, however, that when an employer receives a request for union representation, the employer has three choices. First choice, grant the request. What does that mean? It means that no more questions. We wait, we make a phone call, or we send somebody out to bring in the union representative. When the union representative arrives, the questioning proceeds. Incidentally, it always comes up when the worker requests a union representative, is he restricted or is she restricted solely to her steward, if there is a steward for her department? Or can she ask for someone else to come and help her, to be her representative? And the case law is very clear. She has the choice. She can ask for the steward, and that's in many cases the most logical choice. However, in some cases, the steward is brand new and somewhat inexperienced in handling these types of issues. The worker may want to have someone with more experience, such as the chief steward, such as the union president, such as a steward from another department. The worker has the right to select who is going to represent the worker, as long as that person is available. If we're talking about a worker, you ask for another steward over the chief steward, and that individual is not in the workplace that day, is on vacation, or is out sick, the employer doesn't have to delay the interview and can tell you to pick another representative who's present, so we don't have to have that delay. The selection process can actually go beyond the individuals I've mentioned. A worker can ask that a business agent be brought in to represent him or her. And if that business agent is available, if that business agent can get there in 10, 20 minutes, 30 minutes, maybe an hour, the employer has to facilitate that, has to allow that phone call to be made or make that phone call for the worker. The worker can even demand or insist that he or she wants to be represented by the union attorney. And if that request is made, the employer would have to permit the worker to call the union attorney or put a call somehow to the union attorney. Now, I don't necessarily recommend that, because in many cases, the union attorney may not be available on short notice. And in many cases, the union steward or chief steward or union president can do just as good a job as the union attorney. Following the Weingarten request, the employer is said to have three choices and has to pick among those three choices. First, and the one that we prefer, of course, is that the employer grant the request, put the call in to the representative or send someone to get the representative, stop asking questions, take a break. We wait for the union representative to arrive in the room. However, the Supreme Court said that an employer did not always have to grant a worker's request. As a second choice, the Supreme Court said the employer could tell the worker that you have the right to have a representative, but I also have the right not to conduct this meeting. If you are going to insist that the union steward come or the chief steward, I'm going to exercise my right and I'm going to discontinue the meeting. The meeting is over. You can go back to work.
Robert, can you just be mindful about the cord? When it moves too much, do we get some static?
Okay. So in that case, what the employer is thinking to himself, if they bring in the steward, I'm going to lose my advantages. The steward's very good, very effective. The steward will have private discussions with the worker, and I won't get anything out of this interview. So I am going to tell the worker that if he demands and insists on union representation, I'm going to discontinue the meeting, and I will make my decision based on other evidence, such as interviews with other people or documents or videos. So, of course, that puts some workers might feel a little troubled in that situation. They feel that they can talk their way out of it. They didn't really engage in misconduct. They want to have their opportunity to do that. The employer is telling them, the only way I'm going to let you do that is if you come in here alone. It's up to the worker to make his decision or her decision. I think as the union, we would try to educate workers not to make that decision, because you may think that you're so smart and and know so much that you can talk your way out of things. And in many cases, you will talk your way into things. It's a labor law, labor relations, the law of the shop, just cause. These are topics which union reps over time learn and master and can bring into the meeting to your advantage. You don't have that experience, and you may well talk yourself out of the shop. Just take an example. A worker is brought into a meeting, and the boss says, we're investigating whether we think you were smoking marijuana in the men's room yesterday, because we have some evidence that the supervisor was in the men's room as soon as you left and could smell the smoke, and we're pretty sure that you were the person involved. That's a very serious charge, very serious offense. The worker denies it, that's a sort of a sensible reaction, denies it, but thinks that in order to make my denial credible, I'll add a little bit of, I'll make a few admissions. And so the worker responds by saying, no, I wasn't smoking marijuana yesterday. I've only smoked marijuana once since I've been here during the workday. Now, for some reason, the worker may think that that's going to help his or her case because it shows that she's an honest person or he's an honest person. What we know as a steward is that anytime you admit to using drugs on the job, you're admitting to something which will put you out of the shop. That will lead to a discharge notice. So that's why I say we want to discourage workers from conducting these interviews by themselves. The third option the employer has is to offer the worker a choice. A, we can continue this meeting without representation, or B, I'm ending the interview. Well, that sort of combines the first two. And in that case, we probably would want to encourage our members to exercise their rights to end the interview. Okay. Assuming that the worker has made a good request for representation and the employer has agreed to allow or to provide or to call the steward into the meeting. And let's say you are the steward or you are the representative and you come into the meeting. The Weingarten decision provides that you have definite rights during that meeting. According to the Supreme Court, you are there to assist the employee, to aid and assist the employee in dealing with the questions from management. What does that mean concretely? Well, as a first matter, as an initial matter, the Supreme Court and the court decisions that have followed make clear that a steward or other representative can insist that the employer start out by stating the charges that are being investigated. So, in other words, you cannot be just called into the meeting. Open the door, you come in, the employer points out a chair, you sit down, he thanks you for coming, and then he turns to the worker and he says, where were you at 3 o'clock yesterday? In other words, he begins the questioning. You have no idea as to what is being investigated. Well, how are you going to give advice to the worker? How are you going to help that worker unless you know exactly the specific charges which are being investigated? Are we talking about drug use? Are we talking about accidents? Are we talking about safety? Are we talking about attendance? Are we talking about harassment? Are we talking about any of the hundreds of possible reasons for investigatory interviews? The cases say that the employer must inform the steward as to the specific charges being investigated. That we're investigating possible drug use. We're investigating harassment. We're investigating. Now, does the employer have to give a long list of specifics as to the evidence it has, when these charges may have occurred? Answer, no. The only thing the courts have said is that you must be provided a summary of the specific charges. You must be given the names of a summary or description of the conduct that is being investigated. So let's say that you make this request. Can you tell me exactly what we're here for? What are you investigating? And now the manager gets back to you and says, no way. Your job when you come into this meeting is to be a witness. This is a common response. You sit in the chair, you listen. If you want to take notes, but otherwise I don't want to hear your voice. And now goes back to the worker. Where were you at 3 o'clock yesterday? What should you do, or what can you do? Well, this is my suggestion. My suggestion is to immediately stand up and say to the employer that you are entitled, that you know that you are entitled, and under the labor law, you must be told the specific charges being investigated. That is part of the Supreme Court, it's part of the State Labor Board, it's part of the National Labor Board. It's well accepted across the entire country. And if you don't provide me with this information, you are in direct violation of the worker and the union's labor law rights. And there will be charges at this NLRB or the State Labor Board. Furthermore, if you still refuse to give me the specifics being charged with, I am going to instruct my member not to answer questions. My member doesn't have to answer questions unless you comply with his or her Weingarten rights. And that's the position I would take if I was the steward in that situation. Now, assuming the employer eventually does give you the charges, at that point, can the employer turn to the worker and start to resume or begin the questioning? The answer is no. Because the Supreme Court and the courts that followed have made clear that we have another right. And that second right as a steward or representative is to demand a private meeting with the employee to discuss the charges and to prepare for the questioning. Another name for that kind of private meeting is called a caucus. We have the right to have a private meeting or caucus with our member and to have time to discuss the case with that worker and to give advice. So how can that be accomplished? One, the employer could leave the room, leaving you alone with the worker. There's your caucus. Or two, the employer could allow you and the worker to leave the room and go to another room, or I suppose meet in the hall if the hall is private. You must have some privacy, and you must have enough time to have an intelligent interview. We're talking, I would say, a minimum 10 minutes, maybe 20 minutes in that area. When you meet with that member, you have opportunity to learn about the case, about the situation, and to give advice. So my suggestion is that you might start out by asking the worker what he thinks is going on here, or what she thinks is going on here. And you will get the story from the employee. You can ask some questions about it until you're satisfied that you understand the situation as best you can. At that point, you have the opportunity and should take the opportunity to give the worker some advice before returning to the meeting. What types of advice make sense? Well, on some level of conduct, simple things perhaps. We're going back to the meeting. They're going to ask you questions. It's important that you keep your cool, that you don't get excited, that you don't lose your temper, that you don't lash out at management, that you don't call management and all company personnel liars and bullshitters, that you don't use profanity, that you come back and you answer the questions in a calm but a firm manner. Because we want to point out to that worker that they may not have the goods on you. They may not have enough to take action. In fact, they probably don't have enough to take action. That's one of the reasons they're calling you in, to try to buttress their case. But you may have a great case on the merits, but if you go back to that meeting and you're defiant, and you scream at management, and you yell, and you disobey, and you're insubordinate, and you lash out, and you can be disciplined for that type of misconduct. And certainly, if you go back in and you start, if you refuse to admit to anything, some workers think the best thing is just to deny everything. So when the boss says to you, did you go to the men's room yesterday afternoon? And the worker says, absolutely not. Well, the worker may think that he's helping himself, but probably he's not, because management probably has clear evidence that they have witnesses who saw you in the restroom, or saw you leave the restroom. So when you lie about that simple question, one, it puts into doubt everything else that you say at the meeting. And two, you can be disciplined for lying during the meeting, for dishonesty during the meeting, up to and including discharge, even if they could never prove the actual charge that was brought against you. Let's talk about one situation that comes up quite often. The worker talks to you during the private caucus, and the worker admits to you that he or she committed a severe form of misconduct: drug use, theft, sexual harassment, physical assault, fighting, whatever the charge might be. Well, how are you going to handle that? You're going to go back in the meeting, the questions are going to come up. The worker's inclined to deny that he took part in that kind of misconduct. And that's fine. That's the worker's choice. That may be the best way to answer those questions. Some workers believe that take the position that they have to answer the question truthfully. That if he asked me if I used drugs yesterday, or did I take some items home with me from the shop, I'm going to have to tell him yes, because that's the way I am. I cannot say something that's not true. That's my nature. Well, if that's the case, then of course he's free to go back and take his chances. On the other hand, you may know as a steward something that he doesn't know, that if he admits to committing one of several offenses, he's out the door. The history of the shop, they have zero tolerance on various forms of misconduct. If you admit any level of that, no matter what the reasoning is, you're out the door, you're fired. So you're going to want to explain that to the worker and say, I can understand your impulse to just be honest and ask for mercy, basically. But on the other hand, I have to tell you that in this shop, if you admit that you used narcotics during the workday or on the job, you're out the door. There's nothing that we can do to help you. So now what happens now? If should the worker go back and just lie, say he didn't, deny the charges? Here's the problem. When that worker goes back and denies the charges and the employer presses him, at some point that worker may break down and admit that he is guilty or she's guilty of those charges. And then the supervisor may ask them, well, why didn't you tell us that before? Why did you deny and now you're admitting? So the worker says, well, I wanted to admit it, But when I met with my steward, he encouraged me to deny it, to lie. Now, that's a bad situation. And that's a situation which we don't want to see happen, because in that situation, the steward is possibly in serious trouble. The steward has caused or has encouraged a worker to lie and to deceive management. And in those situations, charges can be brought against the steward, and the steward could be fired for that. Would not be a stretch. Consequently, I would just say that we would never want to be in a situation where we tell a worker not to tell the truth, tell a worker to lie. I would prefer a different approach. I would explain to the worker the consequences of admitting serious misconduct. I would tell that worker, I'm not telling you what to say. I would make that very clear. I am not telling you what to say. I just want you to know the consequences. And then you have to make a decision as to how you're going to conduct yourself. You say you have a great moral compass. You can't say something which is not true. Well, the consequence of that is that you're going to be fired from the shop, no matter how many years you've worked here. You make a decision as to what you're going to say. Now, I think if you approach it that way, I think you've absolved yourself from liability as telling someone not to tell the truth. What else? What other kinds of advice might you want to tell a worker? Well, one thing that happens sometimes when we're in these interviews, that management wants to confirm that you as a worker are totally aware, are very well aware of the rule in question that you are accused of violating, and that you are aware of the serious consequences of violating the company rule. Now, this information may be in the company rule book, or maybe supervisors give lectures about it. But one of the most common questions when a worker comes back from the caucus is, the first questions, you are aware, are you not, that you are required to lock out your machine whenever it's not in use, whenever you take a break or whenever you close that machine? You are aware that we have lockout procedures which you must follow. Well, the worker is supposed to say yes, and probably would normally say yes. And then the employer will follow up with, and you are aware that the consequence for failure to lock out is discipline up to and including termination. And they expect the worker to say yes. And the answer may well be yes. On the other hand, it's also true that an employer has a duty to educate the workers about what rules are and what the consequences of violating those rules are. And oftentimes we have a defense during an arbitration case that the rule was not well explained to the worker, or that the worker had other reasons for thinking that the rule was not in force. For example, it may well be that the worker knew there was a rule, but observed the fact that many other workers who violated that rule weren't disciplined. Consequently, the better answer would be not, yes, I know the rule and I know the consequences, but one, well, yes, I know there's a rule, but no, I did not understand that the consequence of violating it was termination. And the reason I say that is that I've seen many workers violate that rule in my department, and no serious consequences attended. So you may have a rule, you may have a termination rule, maybe it applies in other areas of the workplace, but as far as I can see in my department, I was not aware of that rule. That would be a better answer. And this might be something that you might go over in your caucus before you go back to work, back to the meeting. Okay, now the caucus is completed and you return to the meeting, and the employer resumes or begins the questioning. Do you have any role during that, at that point? Answer, yes, you have an active role. You have a right, said the Supreme Court, to actively assist the worker. That means you have a right to interject during the questioning. You don't have a right to block the questioning or to argue so vociferously that no questions ever get answered or asked or answered. But you have the right to object. For example, if a question is confusing, you have a right to say, I object, that question is confusing, could you rephrase it? if the answer is kind of tricky, such that it uses words which the worker doesn't understand, or it makes an assumption built into the question that the worker has trouble with, you're allowed to object. If that employer is berating the worker, is harassing the worker during the questioning, you have the right to object and to demand that the employer change the way it asks its questions. You also have the right to, in some way, help the worker to answer the questions. Now, you can't answer the questions for the worker. The employer doesn't have to tolerate that. He's conducting an interview of the worker, not of you. So you can't just answer the whole question, but you can lean over and whisper a short point to the worker before the worker answers the question, which helps the worker to remember some point that you may have made during the private caucus. You might just say out loud. It doesn't even have to be a secret. You may just say something out loud to the worker, which you think will help the worker understand the question or answer the question. You cannot be forbidden. You cannot be forced to stay silent. If the employer demands that you stop speaking, that you stay silent, once again, you assert that he's in violation of Weingarten, the company's in violation of Weingarten. You'll be taking this to the NLRB, and if this continues, you're going to have to instruct the employee not to answer questions. In other words, don't let yourself be bullied, and don't let the employee be bullied. Finally, says the courts, when the questioning is completed and the employer wants to wrap up and leave the room, before that happens, you have the right to intervene by saying something to the effect, excuse me, before we end this meeting, there's a few points I want to make about this case, which I would hope that you would take into consideration before you make a decision about this employee. At that point, you have the opportunity to give your view of the situation, to add information that the employee may have forgotten to put forward, or to explain the points that were confusing from the employee. You also have the opportunity to point out extenuating and mitigating circumstances, which were almost always present in a disciplinary matter. A mitigating circumstance is some aspect of the employee that suggests that he or she is a good worker, cares about the job, is serious, and is likely to, doesn't need to be given a stern punishment for what happened. An oral warning, maybe a written warning, but nothing more than that, because this worker takes the job seriously and wants to be present here. If there's some facts that you are aware of from that worker, you would remind the employer that I hope you're aware, this is a very diligent worker. He stays after work. He gets his job done. He volunteers for overtime. He comes in on weekends. She makes suggestions to improve the work. She helps other workers. When there was a crisis in the company and people had to come in for the whole weekend, she came in. Whatever it is, that is a mitigating factor that shows that this worker has a good attitude towards the work and towards the company. We're going to bring out during this meeting, and this is really the best time to bring it out, because if we wait until the grievance period, we make the same points during steps of the grievance process. But at that point, the discipline decision has already been made. The employee has already been suspended or discharged, and we're trying to get management to change its mind or to admit it made a mistake. It's very difficult. When we're at a Weingarten meeting, no decision has been made. The employer's mind is somewhat open. At least it's not as fixed as it is in a grievance meeting. So anything that we can say at this point to suggest that this worker really doesn't deserve a serious punishment. Now, when we talk about extenuating circumstances, those are factors, outside factors, that show that other people or the company itself is responsible in part for what happened. For example, if a worker causes a serious accident, we want to bring out the fact that the training that the worker had received before the accident occurred was insufficient, was weak. So it's somewhat understandable that the worker made that error. He wasn't properly trained, sufficiently trained. When the employer did the training, the employer didn't concentrate on what it was doing. It was pro forma. There may be other extenuating factors that where other workers in some way did things that led to the events at issue. Now, we don't want to be in a situation where we're informing on other workers, but in a general sense, we can try to bring those points out. So once again, this is a big part of an investigatory interview. Our chance, our one chance to influence the outcome of the case before decision is made. Let me just say a few things at this point about what a steward cannot do during the meeting. I'll try to be a little faster here. One, the steward cannot insist that more than one representative be present. Two, the steward cannot demand that all questions that are going to be discussed or all documents that are going to come up at the meeting be given to the steward before the meeting. In other words, before we have this meeting, I want you to give me all the documents that you're going to be looking at or asking about. And I want you to give me a list of all the questions you're going to ask. We're not in a position. We don't run the investigation. The employer runs the investigation. The employer has a right to investigate. Three, we can't answer questions for the employee. Four, we cannot repeatedly interrupt the questioning or otherwise try to block the examination. And five, we cannot raise issues that are not related to the investigation so as to disrupt, delay, or impede the examination. Okay, now I want to just turn to a few sort of legalistic type questions that have come up a lot in Weingarten workshops. One, suppose a worker is called in for a meeting with management, but is told that that worker is not a target. We want you to come in. We want you to meet with management. We know you were present during certain events that occurred in the shop. There was a fight, and we know you were in the area. We just want to ask you what you saw in that fight. Now, in that situation, does that worker have a right to have a union representative present? It's an interesting question, because on the one hand, the employer will say, well, that worker did not have a reasonable apprehension that he or she could get in trouble. She wasn't the target. We told her she wasn't the target, that other people, we were investigating other individuals. So in that situation, can a worker reasonably assert a need for a union rep? Is that a legitimate demand? And the answer here, yes, but only if the worker explains as follows. If the worker says, I understand I'm not the target, but I am concerned that if I was to admit to you that I observed certain things that went on in the shop, I was a witness, you might come back on me in some way on the grounds that I should have reported that earlier, that I shouldn't have waited until I was called in for a meeting. I should have, according to even company rules, if you observe misconduct, if you observe assaults, if you observe harassment, you are expected to make that known to management. And I don't know if I did that or not, but if I did, I might get myself in trouble along that score. And that's a reasonable point. In other words, in that situation, if there is a company policy that workers who observe misconduct report it promptly, then clearly, if you're called in as a witness a couple of days later, you're a possible target of not of the misconduct itself, but of the related failure to report. Two, another question that has come up in some of these workshops. Suppose you're in the middle of a interview, you've had your caucus, you've given your advice, you've gone back, the worker is answering questions, and the worker is getting himself in trouble. He's making mistakes, he's acting in a misguided manner. Do you have the right as the steward to insist that you have a second private caucus with the worker to try and get things back on the rails? It's a good question. There is no NLRB decision directly on that point. There are some decisions from other labor boards, some federal labor boards, federal employee labor boards, maybe even some state labor boards, which seem to suggest that yes, a steward would have a right to a second caucus. It's a reasonable demand. I encourage you to make the demand, to insist on it, to ask for a second caucus and to be firm about it. But if the employer refuses to give you the second caucus, I don't think we have enough legal ammunition to take the position. If you don't give me the second caucus, this meeting's over. I'm going to tell the employee to stop answering questions. Does Weingarten apply if an employee is told to produce a written statement? So we have a situation where workers called to the meeting, to the boss's office. There's some preliminary discussion. The employer says, this is what's going to happen. I want you to give me a written statement which tells me exactly what happened and your view of it and why you did what you did. And I'll give you, I'll give you 2 hours to write that statement up and return it to me. In that situation, does that worker have the right to request a steward? Answer is yes. Does the steward have the right to sit with the worker and help that worker prepare that statement? Answer yes. And that's good advice because many workers could use that help. Writing those kinds of statements is not easy, and they may forget certain points, and you are able to be with them to write the statement and to suggest points that they may have forgotten or not understood the need to put forward. Last legal question is, can an employer issue a gag order? So what we're talking about, a gag order, is employer conducts a Weingarten interview. You're the steward, you're there, you help out, you have the caucus, you help with the questioning, you give your final statement. The employer calls the meeting to a close, but before you leave the room, the employer states that, as you know, under company policy, these are confidential meetings, confidential investigations. And as you know, as you should know, and if you don't, I'm going to tell you, you are not to talk about this meeting with anyone else in the company, whether it's union, employee, or even supervision. This is between you, HR, and between and you and your union representative. And both of you are under a commitment not to reveal what happened or to talk about it. That's called a gag order. And it was very common for many years. During the Obama administration, the NLRB, which was generally pro-union, issued a very good decision that gag orders were illegal. The gag orders violated the NLRA because they prevented workers from taking part in concerted activity, that is, interacting with their fellow workers and with their union to deal with a problem, to deal with an issue. The Trump Labor Board in 2019 overturned those decisions. And that's why I said earlier, when I said that the Trump Labor Board didn't issue any Weingarten decisions, well, this is the exception. This isn't strictly speaking a Weingarten decision, but it affects Weingarten discussions. And in 2019, the Trump board said, took a position that an instruction not to talk about an investigation during the period of the investigation is not a violation of labor law. It is not a sufficient restraint on union activity to qualify as coercion or an order not to engage in union activity. Because eventually the investigation will be over, a decision will be made. At that point, you can discuss it as much as you want. The decision is off the wall. It's not well justified. It's part of a series of decisions on company rules that are hideous, really, and give management carte blanche to adopt and enforce almost any rule it can imagine. But in particular, it means that an employer can announce that the discussion is to be confidential during the pendency of the investigation, but not any further. So if the company was to say, you are under a gag rule, or you are under order not to discuss this, period, well, that's a violation, because when he says not to discuss this, that would be for a period that continues beyond the date that a decision is made. But if the employer does what it's supposed to do and say, you can't discuss it for the period of the investigation, that is not an unlawful gag order. A few other questions. Does Weingarten apply if employee asked to provide a urine sample? So, of course, what we're talking about here is a situation where employers come under some type of suspicion, perhaps, some kind of, because of the conduct or the way they look, something they said, maybe they were involved in a serious accident, and the employer decides that I'm going to have this employee undergo a urine test to see if he is taking any prohibited substance or narcotics. The worker responds by saying, I need to have my steward. I mean, I can't do that myself. I demand that I have my steward present. Is that a legitimate request? Well, of course, on the one hand, he's not being asked any questions. On the other hand, when you ask somebody to undergo a urine test, it's not a direct question, but you are trying to elicit information from the employee, just as if you asked him a direct question, were you under the influence of narcotics? It's equivalent, and everybody understands that. So we were happy to see that in 2000, I think it was 2015, the Obama Labor Board, actually, I think it was, I may be mistaken now, I have to go back and check. It might have been actually a Trump Labor Board decision. But the latest decision from the NLRB on this is that, yes, employees have the right to request the presence of the union representative for two reasons. One, to decide whether they are going to take the urine test, because they might take the position, no, I'm not going to undergo a urine test. And to discuss whether how to answer that request, that has to be discussed with the union. That's legitimate. But even more interestingly, in my opinion, is the fact that the board said that the union representative can be present during the urine test. Why? To be sure that the correct procedures that attend to those tests were followed. There are many procedures that the federal government has issued dealing with taking urine samples and sending them out to laboratories. And if you read my book on just cause, you'll see it's about 10. There's about 10 requirements to make sure that the sample is taken correctly, it's not interfered with, its integrity is maintained. There's a number of requirements, and I urge you to get a list of those requirements and to have them in your locker or wherever you keep your materials, so that when one of your members is undertaking a urine sample, you're present in the lab, or if it's in the shop, wherever the test is taking place. You have your checklist. You are checking A, B, C, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Now, it's not necessary that you be in the actual toilet, the room where the test is where the urine is, comes about. And I don't see any reason for that. But there's a number of steps before the worker goes into that room, and then there's a number of steps that need to be followed after the test is delivered to the employer, the type of receptacle it's contained in, how it's labeled. There's a number of rules. If any of those rules aren't followed, that test is defective. And if that test should show a positive, we would be able to challenge it, certainly in arbitration. Second, another question, does Weingarten apply to telephone calls? Meaning that a worker is called at home, the boss is on the line, the boss says to him, we're very upset. It turns out that in your department, we had a loss today of 200 units. That's over $20,000 worth of product was defective. And we need to find out how that happened and who's responsible. So I'm going to have to ask you some questions about this. Does the worker in this situation have a right to a union rep? Well, obviously the union rep is not in his house and can't come to the house. Nonetheless, the case law is clear. Yes, you have the right to consult a union representative before you answer any questions, just like you would if you were in the shop. And two, you have the right to consult the union representative as you answer the questions. Now that becomes a little, whether that means that the union rep comes to your house and is with you as you answer the questions on the phone. That would be one way of allowing the union representative to have a role to be involved. But the basic thing is that the basic point is before you answer any questions on the phone, ask for a union rep, and the employer must delay the questioning until you have the opportunity to meet with your representative for all the reasons we talked about earlier. Now, there is an exception. There's always an exception. And the exception would be some type of emergency where there's just no time, where if the employer doesn't get the answers in the next 30 seconds, there could be an explosion. Well, obviously in that situation, he can compel you to answer questions without a union representative. But this is not something that you'll see too often. Maybe in Lebanon, you might see it. 3, do Weingarten rights apply to locker searches? Employer is determined to ask a worker to open his locker to see what's in it, to see whether there's any contraband in the locker. Can the worker refuse to allow, can he insist that before I open my locker, I got to have my steward. I got to talk with my steward. And I want my steward here when the locker is open. Well, the answer is reasonable, yes, if in fact you are under suspicion. If they've asked you to open your locker as an individualized search, this suspicion has focused on you, has come on you, and you're asked to open your locker, you are under the direct suspicion. You're a target. In that case, yes, you have the right to demand a steward, and the company has to wait until the steward arrives and allow the steward to observe the opening of the locker. On the other hand, sometimes lockers are searched as part of a generalized search. Monday morning, everybody is called into some area, told to stay there. At the same time, the company opens every locker because they've heard somebody has said there are weapons in the lockers or whatever. That's a generalized search. You're not the target. In that situation, you wouldn't have a right to have the presence of a steward. Okay, that covers almost all the questions. I have a few tips, practical tips I'd like you to hear before I close the discussion that have come to me over the years because I've been writing about this for years and talking about it for years. Tip number 1, sit near the worker, not the boss. In other words, sometimes there are situations where you have these Weingarten interviews where you have the worker sitting on the right, the boss sitting on the left, and the steward sitting on the left, sitting behind the desk with the boss or whatever. The worker comes in. What does he see? What does she see? She sees management and she sees the union facing her. No. We don't want to give the impression that we are here to help management or to do anything for management. We are here for the worker. We don't want to be in the room. In fact, we do not want to be in the room until the worker is in the room. We don't want the worker to enter the room and we're already in the room. So if you get called to a meeting and you arrive at the meeting, you happen to get there before the worker or the worker has left for some short time, we're not going to go in the room and wait for the worker. We wait outside. The worker arrives. The two of us go in together. We sit near the worker. 2, we want to take notes during the meeting of any Weingarten violations. Anytime the employer or the manager or the security guard, whoever is doing the interrogator, if he tells us to be silent, if he tells us to shut up, if he tells us not to talk, if he denies us any of our rights to hold a caucus, if he doesn't respond to any of our objections, we want to take a note of that. Those are Weingarten violations. These violations will allow us to file a Weingarten an unfair labor practice charge at the state or the federal labor board, and we will have the evidence in our notes. Also, I advise to record the names of anybody in the room on the employer side who's taking notes. Sometimes we have these meetings and there's 3 or 4 people on the employer side, and they're all taking notes. Well, let's write that down. Let's keep note of which employer people are taking notes, because sure as hell, if this case moves into the grievance process, we are going to be demanding copies of all notes taken by employers, by the employer or his or her representatives during the meeting, not simply the main interrogator, but the secondary interrogator, anybody in management. We want a copy of those notes. We want to see what was in the notes. We want to see what management had in front of it when it made its decision to impose discipline. Finally, last tip, in extreme case, advise the employee to assert his or her Fifth Amendment rights. What do I mean here? I'm thinking of a situation here where there's no way a worker can go back to the room and answer the questions and stay on the job, either because the worker is someone who is always going to tell the full truth, or for some other reason, there's no way this worker is going to survive an examination by the employer. Is there any last ditch alternative? Well, one that has been suggested, and I'm not necessarily endorsing it, but to tell the worker that you got to go back. If they ask you questions, my suggestion to you is to say to the employer, I am refusing to answer that question because of my Fifth Amendment rights not to incriminate myself. What effect does that have? It's hard to say. A savvy employer, one who knows his or her legal position, would say that's ridiculous. The Fifth Amendment only applies, it's a part of the US Constitution, it only applies when an individual is questioned by a government agency, by the police, or by governmental authorities. It doesn't apply here in a private workplace. You don't have Fifth Amendment rights not to answer my questions. On the other hand, there are some employers who aren't so versed in constitutional law, and they may not be sure where they stand. When a worker says, I am refusing to answer because of my Fifth Amendment rights, they may not know how to respond to that, and they may decide, well, okay, that's your position. That's the end of the interview. In that situation, at least we've saved the worker from providing some major admission that's going to lead to his immediate termination. So that's an hour. I've gone a little bit past my time. I think we have some time for questions if it can be done in this format, because as you know, as you probably can tell, we haven't been able to set the screen up correctly. Okay, Bianca?
Yeah, we're going to go ahead and you can hear me fine, right?
Yes.
So we're going to go ahead and just keep rocking like this. We have a couple people with hands raised, so I figure we can try this format. Thurman Williams, if you're on, you can go ahead and ask your question. Thurman Williams, if you're on, go ahead and unmute yourself and ask your question. Okay, so they're not there anymore. Okay, so let's move on. So we have a question from Mike Gardner. Mike Gardner, are you on? Do you want to ask your question? Unmute yourself and ask your question.
Yes, thank you for the great webinar. I've learned so much, and I see that I have overstepped my bounds. I have 5 questions in the question and answer, and I know I can't ask them all, but let me pick one. Robert, in your book, The Legal Rights of Union Stewards, under author notes, you state that government agencies and their employees are excluded from the NLRB. I'm a steward in Philadelphia, PA, and I work for a quasi city-state agency. Okay, so the state legislature mandated our workplace to oversee the city of Philadelphia in certain things. Am I excluded from the Weingarten because I work in a city-state agency?
I doubt it. I mean, there was a question as to whether your agency is under the jurisdiction of the National Labor Relations Board. And there's a lot of tough questions that have arisen over the years among these quasi-public institutions, such as subway authorities, such as various other institutions which have the earmarks in part of a government agency and also some earmarks of a private sector business. Some court will have to decide whether you are under the NLRB's jurisdiction or not. If you're not under the NLRB's jurisdiction, then I would almost certainly guess that you will be under the state labor board's jurisdiction. You have a federal labor board and you have a state labor board in Pennsylvania. You should be under one of the two. I mean, I suppose the legislature could have written up your agency rules in such a way as to keep you out of both. But my guess is that you are either going to end up being under the feds or under the state. Usually you end up filing a charge at the Fed, at the NLRB. They look at it. The employer says, no, you shouldn't, you don't come under you're not a private sector business. You shouldn't be under the NLRB. And then if the NLRB agrees, they reject your charge and they say you should file your charge with the state labor board, at which point you'll do that. So I think you're under one of the other, but I can't tell you which one.
Thank
I'm
you.
going to rotate between, thank you, Mike, for asking that question. I'm just going to rotate between the raise your hand, the people who raise their hand and the people who put their questions in the Q&A, just to be fair. So the next question is from the Q&A. It's from JP. They ask, are there any clear lines as to what questions are appropriate or inappropriate from the employer in an investigatory interview? Employers tend to treat these as fishing expeditions, and it can be hard to keep workers from self-incriminating themselves over questions that aren't related to the immediate subject of the meeting.
Well, there really haven't been. I mean, I don't know of NLRB decisions or court decisions which have, you know, there may be some arbitrators who have taken offense at some questions that were asked during an investigatory meeting and held it against the employer in some way, but no. And certainly the current NLRB in Washington is not, the Trump Labor Board is not, would never say something that an employer did at a question that they asked was improper. And by the way, it's going to take us probably at least one full year to get rid of the Trump Labor Board, even if Biden wins, because of the way the appointments are made. Biden won't be able to change the board completely, I think at the earliest, December of 2021.
Okay, thank you. So our next question is from Courtney Jenkins. Courtney, if you're there, to go ahead and take yourself off mute. Courtney, if you're there.
Thank you, Bianca, and thank you, Mr. Schwartz. This has been really informative. My question would be, what would your advice be to us shop stewards when we request that private caucus moment if the employer pushes back or tries to refuse that? Like, what are our next steps, and what action could we take?
Well, I think that I would suggest what I suggested if they refuse to tell you the charges. Explain calmly that under federal law, Supreme Court of the United States, you have a lawful right to have a private meeting with the employee before the questioning begins. And if the employer, maybe the employer wants to check with Labor Relations Counsel before it makes its decision, because if you continue to reject my request, you're leaving me with no choice but to file charges against you at the NLRB, and there's no way that you're going to survive those charges. They're going to find you that this interview is an illegal interview, and they're going to take some consequences. There's going to be some consequences. That would be seem to me the strongest way of responding.
Thanks, Courtney, for that great question. The next question comes from Elizabeth. They say, we are a baby union at the Southern Poverty Law Center. Just won our election in December, working on our CBA now. We still have several contested employees. Do those contested employees have rights to union representation under Weingarten?
Well, I think opposition would be yes. Anybody in the bargaining unit that we represent is entitled to Weingarten, has Weingarten rights. It is entitled to union representation. Non-union employees, people who are not in bargaining units, don't have those rights. But anyone who's in a union bargaining unit has those rights. Now, I suppose if a case came up and it was pushed along, and the employer would take the position that this person is not in the bargaining unit for the same reasons that have come up already in discussing the status of that employee, and probably to make a final decision as to whether that employee has Weingarten rights will require a final decision as to whether they are legally in the bargaining unit, depending on the definition of the bargaining unit in the union certification. I don't know what the reasons are that these people are being contested. I mean, for example, one of the reasons for contesting someone is as a claim that management says they are supervisor. If they're supervisor, they can't be in the union bargaining unit. So if it's a person whose status is being debated in that way, but tried to assert Weingarten rights, and it turned out they were a supervisor, they might not have them in the end. But we'd have to talk about exactly where you are in this process of contesting and determining the individual status. If it's just a question of how to count the votes in a union election, and that hasn't been complete, and that's still under appeal, then it may be that we'd have to wait until all that's resolved.
So I know it's 8:30 and we had aimed to end here, but we did go a little bit over the hour. So do you want to take a couple more?
Sure. All I have to do today is walk the dog.
All right. Well, we'll try to get to as many of these questions as possible. The next question is from Marcia. Marcia, if you can hear me, go ahead and take yourself off of mute and ask your question. Marcia.
Okay.
Yep.
Hi. I work for a union of faculty and staff. And my question is two questions. One, what choice does the employee have between lying and telling the truth?
Well, I don't really have a firm answer, and I've gotten in trouble in the past on this because some people, even in the union movement, very strongly take the position that the union should never encourage or allow, they should never get involved in a situation where someone is not telling the truth. Other people may take a more practical view of the matter and recognize that in some situations, the only way a person is going to keep their job is by trying to change the way a situation is looked at. So there's a morality issue here. And I can't tell you, it depends on how hard skinned you are, I suppose. But I can tell you that many unions have won cases by encouraging people to go back to a Weingarten interview and to deny 100% the charges against them. That's one of the most successful ways of winning, of surviving a investigatory interview.
Okay, this next, so this next question, more than a couple people have asked, so I'll ask this one. I'll read the one from Chris, but several other people had the same question. Does an employee have a right to know the topic or agenda of the meeting prior to entering the meeting itself? What if the boss says they just want to discuss a few items or aren't clear about whether it's a disciplinary hearing or not?
And the right to know the charges doesn't arise until everybody's in the room. It doesn't, if you're at your workstation and you're told to go down to a supervisor or to HR, and you say, well, I want to know what this investigation is about. I want to know if there's any charges against me. There's no obligation on the whoever's calling you in to give you an answer. Your opportunity to learn the charges arises when you're in the room and the first, immediately before the questions are asked. Because there have been cases that have come up where workers have said, I'm not going to the room. I'm not going to go into the HR unless I know, one, unless I know what the charges are against me, and two, that I'm going to have my steward. And it just doesn't work quite that way. You do have to, if you don't go to the room, you're going to be charged with insubordination, and it will probably stick. The policy is you go to the room. In the room, you ask for a steward. In the room, you ask to know the nature of the charges. And that's when the duty is put on the employer.
Okay, so our next question is from Nathaniel. Nathaniel, go ahead and take yourself off mute and you can ask your question. Nathaniel, you have your hand raised. You can go ahead and take yourself off mute to ask your question.
Can you hear me?
Yes.
Excellent. Thank you for your time. The major question that I had was when you're discussing the different issues about when you're witnessing a rule violation in the workplace that hasn't been enforced with the same repercussions, or all of a sudden for whatever case, the employee that you're representing is being looked at for termination or for discipline when you've witnessed it elsewise in the shop where it hasn't been enforced. When you note that you've seen it in violation before and it hasn't been enforced to this level, isn't that also bringing up, like, informing on other union members? Like, isn't that just setting it up for a witch hunt and for putting the union into like a liable position?
Well, it's a touchy situation. And I think we may have talked about this on the previous webinar, talking about raising the defense of unequal treatment or lax enforcement. Many times, in order for us to win a case, we need to point out that a rule has not been enforced, or that other employees who have violated the rule have not received discipline or anything more than an oral warning. And to make that argument, we have to be in a position to name names, because the employer is going to say, well, when did this happen? Give me the specifics. If you're in an arbitration, the arbitrator wants to know who is going to sustain a question. Who are these other employees? So you can't open the door unless we're willing to go through it. And on the other hand, from my experience, I haven't seen the repercussions that you have shown a concern about. I haven't seen unions get workers fired or get them in trouble by revealing the fact that they had not been punished for the same misconduct. After all, in many cases, the reasons they weren't punished in the past is that they're kind of friendly with management, or they're.
Uh-oh, we can't hear you. We can't hear you anymore. Did you put yourself on mute on accident?
Oh, you talking to me?
Yes, we can hear you now, though. That's good.
Okay, good.
Okay. So the next question comes from Facebook, and I'm going to combine it with another question. This question is from JJ. The question is, can we get management notes in an information request? What is the best way to handle if they deny that? And then the other part of the question, the person wants to know, can the management demand a steward's notes?
Well, we actually, that's a question that came up last month too. Yes, we want the notes. We want management notes of different types of notes. We want notes that were taken during Weingarten interview discussions. We want notes that were made when they interviewed other witnesses. And we are entitled to those notes in a request for information. We're entitled to make a request for information once discipline action is taken. So after the Weingarten interview, the employee is given a 1-day suspension, given a 5-day suspension, or given a disciplinary warning, a written warning. we file a grievance. Once we file that grievance, or perhaps even as in investigating whether to file a grievance, we are entitled to the records relating to the case, including all notes taken by management and its personnel when interviewing the worker or other witnesses. Now, can management also demand our notes that we took during the Weingarten, because we're taking notes too. We're taking notes during the Weingarten interview. We're also taking notes when we interview other witnesses that we know of. Can management insist on getting those notes? And it's a little tricky, the answer, but our position as a union is no, that there's a different standard that applies to union notes than management notes. Union notes are taken the union takes its notes not because it anticipates litigation. Consequently, we don't have to, excuse me, let me back that up a second. Management takes its notes. When management takes its notes, it's not assuming there's going to be litigation. Consequently, it has to give us those notes. When we take our notes, it's for litigation purposes. We know there's already a grievance. There's a grievance going to be filed or it's been filed. And we're not required to give up material that we prepared to assist us in presenting a grievance. But if you look at the Steward's Handbook, it's a little better explanation.
And just remind people that the Steward's Handbook is also on sale on the Labor Notes website. The next question is from Jessen from CWA. The question is, if a worker has already been found guilty of a fireable offense, what would you advise a steward start negotiating for? Does it make sense to ever do a private sidebar with management without the worker present?
Without the worker? I can't really say about that. I mean, I think there could be, especially if you have a worker who's a very difficult individual, who's going to interfere with a rational discussion, who's going to lose his temper or her temper and blow a thing up. So in that situation, I don't have a problem with having a private discussion. One thing we haven't discussed at all in this evening, which I probably should put on the table, is that many times, many unions will tell you that the way they are, either the most successful technique they have or the second or third most successful technique they have is to go into a Weingarten meeting if the worker is in fact guilty of the charges, and I suppose that's true in some large percentage of the cases, 50%, who knows what, to go that in those situations where the worker is in fact guilty of a serious infraction, or perhaps a series of infractions, or the last of a series of infractions, in a situation where the worker has a very bad case, and we can't really talk our way out of it, the best recourse may well be to go into that meeting and to encourage that worker in the caucus to go back into that meeting with an attitude of what? Of regrets, of apology, of admission, of asking for mercy, to go back and say, yes, I did those things, or I did most of those things. I'm sorry it happened. It won't happen again. Look, I've worked here for 15 years. It didn't happen before. It's not going to happen again. I'm sorry. I'm asking for you to consider the fact that I've been a good worker, and also I'm willing to do anything you want. If you want me to go to a anger management training, if you want me to go to counseling, if you want me to meet with the supervisor privately to develop a plan, I will do anything you ask me to stay in the shop. I like this job very much. I need this job, and I'm asking for just some kindness on your part. So in other words, this is an expression of sincere expression of regret, can be very effective, and that may be I wouldn't rule it out. I wouldn't rule it out.
Okay, our next question, April, you have your hand raised. Go ahead and take yourself off mute and ask your question. April.
Hi, can you guys hear me?
Yes.
Hi, thank you so much. It's been a great webinar. Thank you so much. So I have a two-part question. And I know you covered this, but I kind of missed it because my grandbaby came in and started talking to me. When you are in an investigatory meeting, you were saying that the criteria for that union representation, or you named a couple of things, but my question is this: for when an employer is issuing discipline only, not necessarily asking questions, shouldn't the steward still be present just to as a witness and to keep the employee from putting their foot in their mouth?
Yes, and I think we want that. I mean, as a union, we want to be present. As a steward, you want to be present at that point, for a variety of reasons, some of which you've mentioned. The problem is the law does not require your presence. The law only gives you a right to be present if the employer is asking questions of a nature that suggests that he will use your answer against you. So we don't have a legal right to it. The best approach is to insist or try to get it into the contract. The best approach, and many unions have, as I said earlier, have been successful in getting contract language which guarantees that if management calls their worker in to impose or to announce discipline, that the steward will be notified ahead of time and will be permitted to be present.
Thank you. My second half of my question is, I work for a public employer, and you were saying that the self-incrimination pleading the fifth doesn't work if you're private, but if it's a governmental agency that you could plead the fifth. So if you work for a municipality, and not say the police, but the municipality, can you plead the fifth and that not to incriminate you and it be legal?
Well, I think you're in a little stronger case than someone who's works in a private business or private factory, and your demand would probably have a little more influence on the employer. But technically, I don't think it makes much difference. The Fifth Amendment, as I understand it, applies when you are asked questions by a government agency that could lead to has criminal implications that could lead to your being arrested or sentenced. The fact that you're being called into a meeting with you work in a library and they want to ask you how you have arranged the books, and that could your answers could lead to something negative. They might change your job assignment, they might cut your hours, but that's not I don't think that rises. That's certainly not criminal. There's no criminal. You're not suffering a criminal detriment. So I don't think the Fifth Amendment would technically apply to you either. It applies in situations where a police officer is come in and he's questioned or she's questioned about how she conducted herself with a group of people in the street. How that police officer answers these questions could lead to that police officer being charged with assault or worse. That police officer has a Fifth Amendment right, even though he's being questioned by someone from internal affairs, not necessarily even by the district attorney or by other police. But no, in your case, I don't think you have the Fifth Amendment. But try it. Go for it.
The next question is from Emily. If the employer leaves the room for the caucus, is it possible the room is bugged or being recorded? In some states, it's legal to record people without their consent. Can we ask about it, insist that it not be recorded, or ask for a secondary location? Somebody else asked, could the steward record the meeting? And do they have to say that they're recording?
Well, there's a lot to that. I mean, if you're concerned that the room is being bugged, I mean, if you have some evidence that in the past there was a recording device in that room, that would be certainly be good reason for you to insist that you want to have your caucus in another location in the facility or outside the facility or in the street or wherever. But one point you did raise, which is some states have laws which allow bugging. I don't think any state has a law that allows an employer to bug a private meeting, which the meeting is composed of the worker and his union rep. Because in that situation, you have no consent. Neither of the two parties in the meeting is given consent. It's my understanding that every state either has one-party consent law or a two-party. One party means that they can only record the meeting if one of the two people agrees. Two-party consent would mean that they can only record the meeting if both parties agree. So in the situation that you're describing, I don't think that they would have a lawful, I think they'd be committing a felony in most states or almost all states if they would have bugged that room. So they'd be taking a big chance.
All right. The next.
Oh, as far as can the steward record the meeting?
Yes.
Can the steward record the Weingarten meeting?
Yes.
Well, in part, the answer is there's a criminal issue here because, like I say, some states forbid secret recordings unless everybody agrees. Some states allow secret recordings if one party agrees, and presumably that's the union. So in a one-party consent state, like my state, Massachusetts, it would not be illegal for you to have a secret recorder going. However, you know, if management discovers that secret recording, obviously they're going to be upset and they're going to object. And I have to think it through. There'll be a lot of implications of that. I'm not really suggesting it.
Okay.
I mean, it would make it difficult in the future to have, you know, it's going to make it difficult for them to allow the union to be present in those meetings. I don't know. I don't go for it.
Okay. Our next question is from Wheezy. Wheezy, if you're still there, go ahead and take yourself off of mute. You can ask the question.
Hi, can you hear me?
Yes.
Okay, great. My question is, what are we going to do when we get our first legal medical marijuana patient who has been accused of using marijuana, not necessarily on the job or during work hours? How do we handle something like that?
You mean off the job?
Yeah, but I mean, they take it in the morning or use it in the morning and then they come to work and then they use it when they go home or when they go to bed or whatever the case may be, but it's not actually while they're at work.
Well, I mean, we'll have to see how arbitrators rule on those cases. I haven't seen too many rulings. The company's position is going to be that we understand that some drugs may not be illegal, but they're still narcotics. They still meet the definition of a narcotic as defined in US law, for example. And we are telling you right now that we don't want any employees on the premises who are under the influence of narcotics. And if you test positive for marijuana, which is a narcotic under US law, then we feel we're entitled to terminate you. And I think some arbitrators would probably would agree. So I wouldn't be too comforted by the state law. If the company's rule is clear that they're only taking action against people who are under the influence of a narcotic.
There's a couple questions in the Q&A that are around if your person is not, if your representative that you request is not able to be there in person, would there be a situation where they could call in on a conference and represent you that way?
If they could call in and do it by
phone
or by video, like
or
we're
by
doing.
video, yeah.
Sure. I think that I mean, as a union, I would want to be in the room. I would not want to be sitting in there observing the meeting by video. I would like to be there. I would like to, it seems to me it works out much better for me to be there. And I think if it's only going to be a day or so for me to get there, I would ask the employer to delay the meeting for a day so I can be there. But if it's important for the employer, if the employer says, I have to have this meeting today because there are certain implications of what happened, there's been accidents, there's been product destroyed, I've got to find out what happened right now. In that situation, if I couldn't be there, if I was the steward and I couldn't be at the meeting, I would try to arrange for another steward to take my place.
Okay, and then the next question is from Matthew Gunnett. Matthew, if you're still here, you can go ahead and take yourself off mute and ask your question.
Thank you. Robert, I got a question. Do these Weingarten rights or principles apply to internal union investigations where the union is investigating a member?
No, I can't imagine. I mean, no, Weingarten was promulgated solely in the context of the employer-employee relationship. And by the way, we didn't talk about this, but there's been a long debate about whether Weingarten should apply in the non-union workplace, not to union internal affairs, because no one has ever suggested that. But definitely there's a big issue. Shouldn't Weingarten apply in non-union workplaces when people are called in for questioning? They can't call in the union because they don't have a union, but shouldn't they be able to call in the presence of a co-worker to be a witness to the discussion or to help them deal with the questions that are going to be asked of them? And for a period of time, the NLRB did adopt that rule. But once again, that was changed when the Trump Labor Board took power. So right now, there is no rights among non-union workers. And we wanted that. And we want non-union workers to have that right, because if they had the right to bring in fellow workers to help them during discussions, it won't be long before they decide they want to bring in a real union, because a real union can do the job much better.
Okay, so we're going to end at 9. So we're just going to have a couple more, see how many we can get through. I'm going to give Stephanie an opportunity to come back. Stephanie, if you're still there and you want to ask your question, please take yourself off mute and ask. Stephanie?
Yes, I think, is that me? I guess so. Can you hear me?
Yes.
My question is really, I mean, I think you've answered it. I work for UC, University of California. I'm the grievance steward. And I was just wondering, since it is in fact a public institution, if we could, in a Weingarten meeting, if we know someone is guilty and we don't want them to lie, but you've kind of answered this, could they say, I don't want to answer on the grounds that it might incriminate me, not necessarily taking the fifth?
Well, it's the same thing, but it's not using it's the same means the same thing.
Yeah.
And so I think everything we've said about the fifth applies to that. I think it's a kind of a desperate move, because an employer could call that insubordination. Employees are expected to cooperate in legitimate investigations. And that means answering questions. And when you don't answer questions, it's a form of insubordination. It becomes insubordination, not necessarily the first time when she says, it's going to, I don't want to answer because it's going to incriminate me. That's not insubordination. It becomes insubordination when the employer says that I don't buy that. I am telling you right now, I want an answer to the question. In other words, when the employer orders you to answer and then you don't answer for whatever reason, well, that's a form of insubordination. On the other hand, insubordination may be a better charge to deal with than the charge that brought you into the meeting, which might be a zero tolerance charge. If it is, like theft, it's better to be guilty of insubordination than to be guilty of theft. So if I can avoid the theft by being insubordinate, maybe makes sense. Doesn't always work out that way.
The next question. So quickly, people want to know, is there a time limit on how long management can consistently have you in an investigatory hearing?
Consistently what?
How long can they can you sit straight through and are there any rules around a time limit for how long these things can go on?
Well, I think the rule we do have under just cause is that an employer must take action promptly after discovering misconduct.
I think they mean in the hearing itself.
So is there any time limit on how long they have during the hearing?
Can you question a worker for 5 or 6 hours? Is there a limit,
Yeah.
to
Well, I don't think, I've never seen a technical limit in that be stated, but common sense would say that after a couple of hours and the person is beaten down, that the steward can insist that the meeting be adjourned and come back tomorrow if there's still material that has to be covered. But that's the job of the steward, to come to the aid of the distressed worker.
Cool. And then I think we have time for one more. I'm gonna mispronounce your name, R. Monturi. If you're still there and you have a question, feel free to take yourself off mute and ask.
Thanks. Bob, I got a question. In the investigatory meeting, if it's criminal in nature, just like you said with theft, wouldn't it be more advantageous to invoke your garrity rights?
Yeah, well, you've brought up that's not, kind of a big topic, which is confusing too. And garrity rights is somewhat of a misnomer. When we are representing someone in the public, this is only in the public sector. Someone who's being questioned in the public sector, who's being questioned about some type of misconduct, which could also be termed criminal. That person wants to make sure that if I answer your questions, that you won't use my answers against me in court. You want that the questions won't be used against me in a criminal proceeding. And the steward can help that worker to put that worker in the best position by, quote, asserting the worker's garrity rights, which is a decision called a federal decision called involving a fellow named Garrity, but mainly by getting the employer to agree that, one, I'm asking these questions and I expect you to answer on pain of insubordination charges. Two, that if you, on pain of termination, if you don't answer the questions, you will be terminated. And two, I do not intend to use these charges or have these charges be used in a criminal proceeding. There's certain questions, I think there's 3 questions that we would ask and try to get the employer to say yes to. And once the employer says yes to the 3 questions, then supposedly it makes it much more difficult or impossible to use the worker's answers against him in a criminal proceeding. But this is not a very common situation.
Okay, so you can go ahead and stop sharing your screen.
Okay.
And I just want to thank everybody for joining us tonight. I'd like to remind you that much of what Robert covered is in a chapter of the book, The Legal Rights of Union Stewards, which is available on the online store at labornotes.org. This was the second in a series of webinars that we will do together. So we'll be on the lookout for the next one, for the date and the subject. And then also, as I mentioned earlier, I will send out the slideshow as well as the recording to this webinar to your emails. I'll also be posted on the Labor Notes website. This video will be posted on the Labor Notes website. Give us some time, probably within the next couple of weeks. And then if you also you don't want to wait a couple of weeks, then you always have the option to go back on our Facebook page. If you follow us, Labor Notes, you can see it there as well as we are live streaming. Thank you so much, Robert. It's a joy as always. You dropped so many gems, and I'm sure everybody found this to be so helpful. So thank you for being so generous with your time. And thank you all of you for bearing with us through the technical difficulties. We do hope you were able to take something away from today. And
okay.
Yep.
Are you still hearing me?
I can still hear you.
So let's recap tomorrow and the next day, okay, Bianca?
Sounds good. Good night, everyone.
Bye-bye.
All right, bye-bye.